Nothing more, nothing less.
Mr. Tsikata,
Yes.
do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except by reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5, it reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argue in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say, one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Tsatsu Tsikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why did you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
So in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords,
is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordships themselves expressed, some surprise, and that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Tsikata, when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
So, but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or thrice
more,
already.
Nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we're saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesbury principles. And her ladyship, Justice Georgina Wood, as she then was. In the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Your Ladyship's, her Ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua...
Tsikata, your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koblex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of case, and we rely on it. My lords, under Article 33(1) of the Constitution, this court may review 133.1, my lords, 133.1 of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. My lords, those conditionalities have been set out in Arta number 2 versus Arta number 2 to 2013-2014, 1 Supreme Court of Ghana Law Reports 569 at pages 579 to 580. Lords, I will not read those conditionalities there, but they are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord's, our submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lords, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held, accordingly, in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1, will the evidence, if it had been presented during the trial, have had any influence on the result? 2, could the evidence have been obtained before or during trial by the exercise of due diligence? Then your lordship conclude that thus, in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I submit further that the grounds are very misconceived and have no bearing at all on your ratio that I have set out above. Even as submissions were made by the counsel for the applicant, And even as I'm speaking, still, my lords, the court is still not aware. It still doesn't have the inkling of the evidence that the applicant wants to lead, for which the case should be reopened. And Lord, this leads me to the Wadier case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A. And by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous process.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, yeah, to refer to it,
yes,
you can capture it in the affidavit.
Yes.
So
yes.
Don't ask for this one.
No, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court has said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, in civil motion number J7/15/2017. Lords, Doche JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment thus: from the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the effluxion of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration, my lords. Lords, in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently, they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuvel,
yes, sir.
Are you referring to me as a sore loser? Because I argued that application for review before this court. I was standing where you were some few years ago, yeah, and I lost that application.
Well, Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lord's arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. This petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed, file, witness statement no. You yourself intimate that I am going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lords, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuva, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampa.
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A, of petitioner's application, the petitioner refers to Section 72 of the Evidence Act. Now, my Lord, Section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice, and on both occasions this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they had closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around section 72 that the court was per incuriam of section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5, cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E5 is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 3.5 is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court has committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Rule Ground C, which relates to Act 459, Section 58. Ground D. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. My lord, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My lord, this provision presupposes that the party who is applying to summon another has not closed its case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed its case. And my lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My lords, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to order 22, rule order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking. And it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My lords, the fair hearing argument, my lords.
You have 5 minutes more.
Very well.
No, 10 minutes.
My lord, I thought I had a lot more minutes. Unless your lordship thinks I've made out my case, so.
You have 5. Out of the 30, you have 5 minutes more. Thank you.
My lord, ground E relates to the allegation of breach of his right to fair hearing. My lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of the first respondent's right to fair hearing also. My lords, with our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation of to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court, as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. My lords, we are done.
Who's that?
My Lord, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claim she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of Section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So, reading Section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we are in court this morning. Because, my lords, we are in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we are in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of Section 72. And my lord, he completely does not address the point that we make, that Section 72 was not even referred to by your lordships, and that your lordships' ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes, I have one question for you.
Yes.
Your arguments, you dwell mostly on Section 26. Section 26 of the Evidence Act. Can you show me any conflict between Section 26 and Order 38? Is there any conflict between Section 26 and Order 38, Rule 3, E5? Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there is a conflict, and that in the ruling it says this section is not applicable because of Order 38.3e. And my lords will notice that I in fact went on to argue. I argued that Rule 38.3e5 in fact has nothing to do with Section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to a substantive act.
That's what the court said. I mean, I read it. The court said...
No, we didn't say so.
We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38
But it doesn't mean that the court was preferring or raising section order 38, raising 38 against above section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to section 26.
Yeah, but my lord, how can your lordship say that section 26 is not applicable in view of order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider section 26. And there we argued that no reference had been made. It was per incuriam section 26. In that ruling again, no reference was made to section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error. And your lordship should take the opportunity to correct that error, because you didn't make reference to section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
No. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider his ruling.
All rise.
small size of motorcycles make riders vulnerable. Your head is the most delicate part of your body. Your head is not much harder than a watermelon. In the event of a crash, if your unprotected head hits the street, you could suffer head injuries. Crash helmets are designed to guard against severe head injuries in the event of a crash involving a rider. As a rider, before you set off, wear protective clothing and a high visibility vest so you can be seen during the day and night. Make sure you wear a crash helmet to protect your head and ensure your motorcycle is in good condition. Ride safe. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
In Ghana, the environmental speed limit of 30 kilometers per hour should be observed in residential, educational and commercial areas because human activity is dominant. 50 kilometers per hour is for built-up areas and communities along the highway. 90 kilometers per hour is for the highway. The Accra-Tema motorway has a speed limit of 100 kilometers per hour. Where there are no speed limit signs, the national and environmental speed limits apply. So, if you are driving near a school with no speed limit sign, your speed should be below 30 kilometers per hour, so you can stop your vehicle if you need to. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
So we try was suicide. Let bygone be bygone. I can't see what I'm gonna do. We go straight to stardom. I'll take you to the next level. Oh, baby, oh yeah, yeah, yeah. Energy next level. Oh, baby, oh yeah, yeah, yeah. I'll take you to the next level. Oh, baby, oh yeah, yeah, yeah.
I don't quote next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Don't forget the balloons, check. The DJ,
check.
And the drinks.
Listen, honey, I've got this party under control, okay?
Daddy, don't forget our birthday cake with the